Good afternoon. My name is Yee Htun, and I'm a clinical instructor and lecturer on law at the International Human Rights Clinic at Harvard Law School. I'd like to welcome you all to joining us on this webinar entitled Freedom of Religion and Public Interest, hosted by the Program on Law and Society in the Muslim World. It is co-sponsored by the Human Rights Program at Harvard Law School and our student practice organization, HLS Advocates for Human Rights. I want to thank you all for joining us today, those of you from the Harvard community, as well as other participants from around the world. Before we get started, just a bit of housekeeping. Namely, our audience throughout the webinar will be muted. This webinar is being recorded and it'll be made available afterwards on the social media platforms of the Program on Law and Society in the Muslim World. Our plan is that we're going to have about 3-minute main session, have our guest speaker discuss with us, which will be followed by a 20-minute Q&A. So if you have any questions for that session or at any time in this webinar, please be sure to type it into your box in the chat box at the bottom of the screen, and we'll try to get to as many questions and answers as possible. Without a further ado, I'm going to introduce our guest speaker today. His name is Gehan Gunatilleke. He's a visiting fellow at the Program on Law and Society in the Muslim World. He is a graduate of Harvard Law School, where he obtained his LLM in 2010. He's a lawyer specializing in human rights and constitutional law. His current research at the Program on Law and Society in the Muslim World focuses on the relationship between identity politics, constitutional discourse, and the ethno-religious violences in Sri Lanka. He's also the author of The Chronic and the Entrenched Ethno-Religious Violence in Sri Lanka. So thank you very much, Gehan, for taking the time to discuss this really important topic with us today. I'm going to turn it over to you now.
Thank you, Yee. Let me just share my screen. Are we good to go? All right. Let me begin with just setting out the structure of today's talk. I'm going to speak in two segments. The first segment is really going to be about limitation clauses dealing with freedom of religion or belief. And I'm going to discuss some case studies from Sri Lanka, Pakistan, and Europe. And in my second segment, I'm going to talk about a possible response to the challenge that I outlined in my first segment. And I'm going to call it the good faith interpretation of limitation clauses. Let me also set out the parameters of today's talk. This will hopefully also indicate what kind of questions and answers we'll hopefully get into at the Q&A. So really, freedom of religion or belief is not recognized as an absolute right or freedom under law. It's one of those rights that can be legitimately limited, both under national constitutional law and international law. So what I'm going to discuss today is possible vulnerabilities of these limitation clauses, that is, the clauses that authorize states to restrict the freedom of religion or belief. And I'm going to argue that a lot of these clauses are actually vulnerable to being shaped by majoritarianism or majoritarian political discourse. So those are the parameters of today's talk. Let me jump into the first segment, which is essentially going to be a bit of a critique of the orthodoxy around how limitations are actually enforced in practice. So we get a variety of limitation clauses in national constitutions. I'm going to take a couple of examples from South Asia, one from my home country, Sri Lanka, which sets out in Article 15, paragraph 7, a basis on which, or several bases on which, the freedom of religion or belief, and specifically the freedom to manifest religion or belief, might be restricted. These include interests of national security, public order, public health or morality, and a very broad phrase that is termed as the general welfare of a democratic society. Quite similarly, you have the Pakistani constitution, and Article 20, which deals with the freedom of religion or belief. It says that this freedom is subject to law, public order, or morality. Now, you'll already see some similarities in the terminology that is used in limitation clauses. Let's jump to international law quickly, just to give you a sense of what you might find in limitation clauses. You get both these types of limitation clauses in both international and supranational treaty law, that's regional regional treaty law. If you take the ICCPR, the International Covenant on Civil and Political Rights, Article 18 deals with the freedom of religion or belief. And paragraph 3 of that article, once again, lists out the possible grounds or public interests on which you could have the state restrict this freedom. So you have public safety, order, health, or morals, and you have the fundamental rights and freedoms of others. These are the grounds that this particular treaty provision permits the state to restrict freedom of religion or belief on. If you take the European Convention on Human Rights, this was a treaty that actually predated the ICCPR. Article 9, paragraph 2 permits states to restrict the freedom of religion and belief on public safety, public order, health, or morals, or for the protection of the rights and freedoms of others. Now you'll see a pattern here. These are essentially the types of interests that are used to justify restrictions on FOB. I'm going to use the word FOB to save me some space and time. So you'll notice the word public is often attached to these various interests. So it's, I think, legitimate to call these interests public interests. But the argument I'm going to make is that these public interests actually stand for majoritarian interests. But before I get to that argument, the typical criteria that you see implemented or enforced when a particular limitation is being adjudicated upon or assessed or evaluated in terms of this, the treaty provision, goes something like this. The limitation must be provided by law. So essentially, only legal limitations are considered. This is found in a variety of national constitutions, and it's certainly one of the criteria found in both the ICCPR and the European Convention on Human Rights. The limitation must be necessary for the advancement of one of those interests. So I mentioned a variety of interests that keep popping up in these limitation clauses. It has to be necessary, and the doctrine of necessity is often used as one of the conditions. And you might be familiar with the concept of proportionality. That's where the harm caused to the freedom concerned mustn't be or must be actually outweighed by the benefit gained by the interest, or in terms of the interest that is being advanced. So for example, if there's harm caused to a particular community that's trying to practice a particular religion through this restriction, that harm must actually be outweighed by the benefit that is accrued in terms of, say, the interest of public order or public health. And that balancing act is what takes place when limitations are adjudicated upon by courts and tribunals. So this is the typical criteria that a court might consider when evaluating a limitation. Now, here's the challenge, and this is what I want to try and discuss today in this talk. A literal reading of these clauses often permits states to infuse majoritarian interests when shaping a limitation, when interpreting a limitation clause. And that becomes highly problematic, particularly in countries with religious minorities. And I'm going to take several case studies to illustrate this point. So what happens in practice is that the word public, the notion of what is public, becomes synonymous with what the majority's views might be on things like safety, order, health, morals. So it really becomes the majority's sense of safety, the majority's sense of order, the majority's conceptions of what is in their interest in terms of health, and the majority's conception of what is moral and immoral. These conceptions become what gets applied in practice as public interests. And I'm going to take some examples to show how this actually works in practice. So let's jump into the case studies. I'm going to start with Sri Lanka, and most of my research at the moment focuses on Sri Lanka, although I do a little bit of comparative work as well. And hopefully in the Q&A, Yee, we can discuss some similarities across the region. But you'll notice that what I'm talking about has very little to do with the specific religious community concerned and all to do with the status that the community occupies. So you might have, say, for example, the Muslim community as a minority in one context on the receiving end of restrictions, but the Muslim community in another context being the majority in that particular context, being uh, at the other end of the spectrum where they're advancing specific majoritarian interests through the state's imposition of limitations on religious minorities that are non-Muslim. So really you can see, I'm taking some diverse examples to show how it's really about majority minority status, and it's about power and prejudice rather than specific religions or religious communities. So in Sri Lanka, just to give you a sense of the demographics, the population is over 21 million, and we have 70% of the population being Sinhala Buddhists. So that's an ethno-religious community that clearly occupies the majority status in the country. More than 2/3 of the population come from this community. And then you have ethnic communities like the Tamil community and the Burgher community, and you have the Christian community, which is a religious community that could come from either the Sinhala community or the Burgher community, and as well as the Tamil community. And you have the Hindu community, which is typically Tamil. And then you have the Muslim community, which constitutes just under 10% of the population. So that's just in a nutshell the demographic background in Sri Lanka, just to give you a sense of what the dynamics might be. So recently, with the outbreak of COVID-19, just in 2020, there was an announcement that cremation will be the only method through which one could dispose of a body, of a person who is suspected of having had the coronavirus. So it was a directive that was issued by the government. There were questions raised as to whether this was done through legal means, but leaving that aside, the directive was mandatory and it mandated cremation as the only form of disposal of corpses. Now, the directive had a neutral framing. It didn't target any particular community. But what it did was it legitimized, or it really propelled, the ordinary practice of disposing bodies of one community and effectively prohibited the ordinary or typical practice of disposing bodies of other communities. And it therefore had a discriminatory effect, particularly on the Muslim community, whose ordinary means of disposing bodies, according to Islamic teachings and interpretations of Islamic teaching, had to be burial. So really this effectively was a prohibition on burial, and that was something that of grave concern to the Muslim community in Sri Lanka. Now, what was the justification for this restriction? Effectively, this is a restriction on the freedom of religion or belief because it is a religious practice to bury one's dead, and the Muslim community asserted this as part of their freedom of religion. Now, the justification for restricting this particular practice was public health, because we had a very serious pandemic and there was an outbreak of the virus in Sri Lanka. And the justification was that through cremation, we would be able to restrict the spread of the virus as opposed to burial. And it was asserted that burial came with graver risks. Now, there was very little scientific evidence to back this claim, because in fact, at the time, the WHO had released some guidelines on this very issue and had clarified that it does not make any difference as to whether one buries a corpse or cremates a corpse, as long as certain guidelines are followed and public gatherings are restricted. So really it wasn't about the mode of disposal, it was about the various practices around the disposal that one had to regulate conduct. So immediately questions were asked as to whether this was actually necessary for public health. Remember, I mentioned the criteria. It has to be by law, it has to be necessary for a particular interest, and it has to be proportionate. And of course, whether this was a disproportionate restriction on the freedom of religion or belief of one particular community. Of course, the, the the mandatory cremation continued. There was some discussion as to whether it could be relaxed later on, but essentially this is an example of how a particular community's conception of public health and a particular community's practice that is deemed to be contrary to the dominant practice can be targeted through the use of a limitation regime. Because technically you could argue that this was a restriction that was in the interest of public health. And the Sri Lankan constitution actually permitted restrictions of that nature. So what I'm doing here is trying to actually critique not just the practice, but the legal norm itself, and ask the question as to whether the legal norm has to be subject to a different type of interpretation to get over these practical problems. Let's take an example from Pakistan now. Now, in Pakistan, we have the Sunni Muslim community as the clear majority. So we have a different context to the context in Sri Lanka, and we have several smaller groups, religious groups, and one of those religious groups is called the Ahmadiyya community. And we've had for a very long time restrictions on the Ahmadiyya community's ability to present themselves as Muslims in public. And often they would do so by wearing attire that displays an Islamic kalima. And on several occasions, they've been prevented from wearing such attire because there's a whole dispute as to whether the Ahmadi community is genuinely Muslim. Now, again, the justification for these restrictions have been the standard interests, like public order, like public morals. You'd notice in Article 20 of the Pakistani Constitution, you have both these grounds very specifically mentioned as grounds on which the freedom of religion or belief of a community could be restricted. So what the court in numerous cases have done, and how the state has justified this limitation, is that displays by this minority community that assert their Muslimness in public would actually outrage the majority community and could cause civil unrest. So it's kind of similar to what you might encounter in the free speech discourse as the heckler's veto. Really, because of your expression, which doesn't directly harm anyone, there could be a reaction to that expression that is harmful. And that was the justification used to restrict the Ahmadi community's ability to express their beliefs in public. In addition to that, it was also asserted, particularly in the Supreme Court in a case in 1993, that public morals is really based on a Sunni majority community's conception of what is moral. And it would be an affront to those morals to permit this other community, the Ahmadi community, to assert themselves as Muslims. It would be an affront to morality. Again, the conception of morals is defined by how a majority sees what is moral and what is immoral. Final case study, and this is really, let me check my time as we go along. Yeah, this is from Europe, and we're quite familiar with these cases. You've had in places like France, Switzerland, Belgium, Turkey, bans on certain types of Islamic attire. So in France, you've had a recent ban on the wearing of the burqa or niqab. You've had in Turkey banning of the Islamic headscarf, particularly in places of education and public spaces. And often these bans, which clearly are restrictions on freedom of religion or belief, and particularly the manifestation of religion or belief, these bans are often justified on those very grounds that I mentioned: public order and the rights of others. And I'm going to try and deconstruct this justification a little bit. So in numerous cases, particularly before the European Court of Human Rights, just to mention a few, Leila Shaheen versus Turkey was a famous case involving Turkey's ban of the Islamic headscarf, and then you have SAS versus France, which was looked at, again, Islamic attire. The justification that is presented by the state is that these expressions of religious identity are incompatible with European values of secularism and living together. And these values are couched in terms of public order. Now, you may immediately ask the question, what does public order have to do with these specific grounds? Well, particularly in continental Europe, the concept of public order, or let's say the conception of public order, is actually quite broad and expansive. And it dates back to even discussions amongst drafters of the ICCPR. It was actually a very interesting disagreement between the French representative on the committee that drafted the ICCPR and the British representative. And in fact, the disagreement hinged on which conception of public order should be adopted in the ICCPR. So the British conception was much narrower. It was really the prevention of disorder, unrest, riots, whereas the French conception of order was very expansive. It actually stood for the fundamental values on which a society could be built. It was akin to something like public policy in the Anglo-American tradition. So really, when you invoke the term public order in, say, a French setting, what you're really doing is invoking a whole range of values, which is why things like secularism and living together are often couched under the umbrella term of public order in continental Europe. And of course, it was also justified on the basis of the rights of others, the rights of people to live in peace and harmony could be violated by individuals wearing the headscarf or the burqa or the niqab. That was the kind of justification given. And incidentally, the European Court has often upheld these restrictions and upheld the state's limitation on these grounds of secularism and living together. So what are some of the commonalities in these case studies? This is before I move on to the second segment. We see in all these case studies, the state relying on grounds of public interests, which are clearly found in the limitation clauses. They're not pulling grounds from out of a hat. Even when they advance grounds like secularism or living together, they're couching it in terms of a specific limitation ground already found in the limitation clause. But what we're seeing in each of these cases is a majoritarian conception of what these interests actually mean. So majoritarianism actually shaped the scope of each of these interests. And these examples clearly indicate that practice. And the sort of consequence of that is that these limitations pose a major threat to the rights of religious minorities whose practice and beliefs may not harm anyone, but are actually antithetical or opposed by the majority community or the majority discourse, community's discourse, political discourse in that particular context. I'm going to pause there, Yee, and maybe move on to the second segment if there are no sort of burning questions.
Great, thank you, Gehan. Those case studies were really illuminating as far as the experience of the minority challenges facing minority communities in those. I'm just curious, before we move on to the good faith, if you could tell the audience a little bit about sort of what position should the courts and civil society respond in these settings that you just presented, whether it's Sri Lanka, Pakistan, or even the larger Europe.
Okay, I think that question takes me into the second segment quite nicely, because what I want to try and do is think about responses. And this is, of course, work in progress in a sense, because it's part of my research. So I'm really curious to see what others have to say as well. What I'm proposing, of course, is a legal approach. It's a doctrinal approach, and it's not to be sort of the only alternative out there. It needs to complement political discourses, cultural transformative discourses, and I think it's not really a panacea to this problem. What I'm presenting today is just perhaps one element of the response we need to have, and this is a legal doctrinal response that I'm going to talk about. So just to articulate the problem a little bit, when I'm responding to your question, I think the problem that we're seeing is that current practice, particularly at the national level, is switching uh, the relationship between norm and exception. So really, when you think about the freedom of religion or belief, if we're serious about the freedom, if we understand this as a serious Hegelian liberty and claim right, uh, it's the freedom that should be the norm, and the limitation should be the exception. And if I were to borrow the sort of terminology of Gerald Gauss, who talks about the liberal fundamental principle, or the fundamental liberal position, it's that freedom is the basic norm, and it's coercive restrictions on freedom that needs to be justified. And that, therefore, the justificatory burden is really placed on those who impose the limitation. But what we're finding in practice is that the justificatory burden is shifted to those asserting the freedom. If you're in Sri Lanka, it's the Muslim community that seemingly has to assert its freedom to bury the community's dead, as opposed to the justification of the restriction on that practice. In Europe, we see people who want to wear particular attire having to demonstrate and having to justify the practice. The limitation seems to be the norm, because it's in line with the majority's conception of what's important in that society, secularism and living together. In Pakistan, similarly, it's the Ahmadiyya community that has to actually demonstrate and prove that the practice that it's engaging in is actually not harmful at all, and it's not going to result in major civil unrest. And it's the limitation that seems to be the starting point of the discussion. So you see this flipping between norm and exception. And I think that's the problem in a nutshell. What I'm going to propose in a few short minutes is that this problem can also be approached through a doctrinal interpretive sort of strategy or tactic. And I'm couching it in terms of good faith. And now, of course, the term good faith is broad, it's abstract. The criticism could be leveled against me that, you know, you're just bringing something very vague into the discourse. But I think I'm not setting out a formula for interpretation. I'm setting out some normative parameters. And I think good faith interpretation is not alien, at least in international law, and certainly not alien in constitutional interpretation. So in both the international and domestic levels, the idea of good faith is actually quite central to legal interpretation. Now, at least in international law, we have a good basis for good faith interpretation. Any international lawyer will be familiar with Article 31 of the Vienna Convention on the Law of Treaties. This convention asks states and anyone who interprets a treaty to interpret the treaty in good faith, in accordance with the ordinary meaning that could be given to the provisions, to be cognizant of the context of those provisions, and most importantly, keep the object and purpose of that treaty in mind. So the object and purpose of the treaty, what the treaty's framers really set out to do through this treaty, has to be kept in mind, and it's quite vital to interpreting the treaty in good faith. I think national constitutions have the identical doctrine. A lot of progressive courts have relied on the concept of good faith and constitutional good faith when interpreting particularly provisions dealing with fundamental rights. So I think this has to be the normative terrain that we occupy when we approach this challenge. Now, in the case of the ICCPR, the idea of covenant compatibility has been quite important to advancing good faith interpretation. So I'm giving you an example of how this could be done, and illustrating how at least one treaty body's work is giving us a sort of signal in the right direction. And I think according to the work of the Human Rights Committee, which is the treaty body tasked with supervising the implementation of the ICCPR, it's come up with the idea that all limitations must be compatible with the object and purpose of the treaty. Now, this sounds like rhetoric, but in practice, I think it's enormously useful in terms of constraining the state's authority to restrict freedom of religion or belief. So a good example of this is actually the Human Rights Committee's work on non-discrimination, particularly in the context of freedom of religion or belief. So how does it really work in practice? I'm going to give you one example, or a couple of examples actually. The Miriana Hebaj and Sonia Yeka cases that were recently decided by the Human Rights Committee just in 2018 are really interesting because it takes the absolute contrary view taken by the European Court of Human Rights. And this brings up all kinds of problems for public international lawyers. There's the whole problem of fragmentation as a result of different adjudicative bodies taking completely different positions on very similar issues. But of course, the committee is evaluating the limitation. This is on the burqa. In terms of the ICCPR, and of course the European Court is evaluating the limitation in terms of the European Convention. But of course it's the identical issue. And in this particular case, the committee deviates from the court's position and sets out the position that limitations must comply with the principle of non-discrimination. Now that sounds like a pretty straightforward statement and a pretty straightforward doctrinal position. What's interesting about that position is that it's actually relying on a covenant principle that's not found in explicit terms in the limitation clause. So Article 18.3 of the ICCPR actually doesn't contain the condition that the limitation must be compatible with the principle of non-discrimination. The committee is actually drawing that out from the rest of the covenant, which is why I'm calling this principle the sort of covenant compatibility principle. So here's a good example of how a tribunal or an adjudicative body can bring in the concept of a good faith interpretation into the actual practice of limitations and actual enforcement of limitations. And even though in technical terms, a limitation may be compliant with the parameters of the limitation clause, once it's read in light of the entire treaty, it could be deemed impermissible. And that's precisely what happened in these two French cases. And it's precisely how the committee deviated from the European Court's position. So what we're really having in these cases is an additional normative constraint being imposed on state authority. And then we go back to that justificatory burden that I spoke about a moment ago. The justificatory burden is placed squarely in the arena of the state, and the expectation is that the state satisfies a substantial justificatory burden when restricting the freedom of religion or belief, particularly of a minority community. Now, some concluding thoughts. I think if we were to advance a good faith interpretation, and this is certainly true in international law, and I would extend this to the domestic setting as well, if courts were to really read constitutions in the spirit in which they were intended to be read by their framers, I think it is possible to doctrinally infuse a heavier burden on states to justify limitations on freedom of religion or belief. And I think this doctrinal approach essentially will place a counter-majoritarian check on the application of limitations on FOB. So really, if the problem is majoritarian infiltration into our conceptions of public interest, what I'm proposing here is a doctrinal approach that would be a check on that. And that check would be principles that we draw from the rest of the statute or the rest of the treaty to constrain the state's ability to restrict the freedom of religion and belief. And I really think that if it's applied correctly and consistently across jurisdictions, states would be restricted from pursuing interests in a manner that actually deviates from the object and purpose of the treaty or the instrument, and could create a counter-majoritarian check on the limitation or freedom of religion or belief of minorities in particular. I'm going to just pause there, Yee, and maybe take some more questions.
Great. Thank you, Gehan. That's really awesome to hear about sort of your proposal on how do we put a check on the majoritarian tendencies that infuse the interpretation of the law. I'm actually curious because I work predominantly on Myanmar, and I feel like there's a lot of parallels between Myanmar and what's happening in your country of birth, and my country of birth, Myanmar, and your country of birth, Sri Lanka, given how infused the ethno-majoritarian, i.e. the Buddhist, Burman, or the Sinhala Buddhists in Sri Lanka have sort of taken over. How important is cultural and political approaches? Is it the first starting point, or is it something that needs to supplement this doctrinal approach? The reason I ask that is that, for example, in Myanmar, you've got a constitutional that is on good faith, on value, something that's supposed to protect minority religions. And yet, in the consistent application, as well as certain national legislation, such as the citizenship law that deprives, for example, the Rohingya Muslims of their right to citizenship, or the four laws, which is the race and religion protection laws, which really on the surface looks neutral framing, but is very much having a discriminatory effect on Muslim communities. How important is it for law reform, or whether the doctrinal approach, to supplement the majoritarian tendencies that are sweeping the nations, specifically the culture and the political? I would love to hear your thoughts on how that might plays out in places like Sri Lanka, as well as lessons that we can learn from in the region from places like Myanmar.
No, I think that's a great question, and I think it'll open up the Q&A nicely as well. Um, as I said, what I'm proposing here is just one part of the necessary response to the problem. Of course, there'll be people who disagree that the problem exists, and I think we need to also engage those individuals and groups who doubt the problem. And I think I'm happy to actually contest that and engage on that front as well. But if we were to accept this problem, and we accept it not as a problem that's unique to Myanmar or Sri Lanka, I was very deliberate in actually pointing to Europe, because Europe is often seen as a region that's actually advanced in terms of human rights, but on this particular issue, it isn't, and I think it's important to frame criticism in terms of majority-minority dynamics rather than communities themselves. So that's the first, I think, approach where communities, even majority communities, are not cornered into being framed as perpetual perpetrators and aggressors, because you're not going to get anywhere by doing that. Really, it's a discourse that you have to advance where the communities are engaged constructively, and the point that you're making is a neutral point in terms of wherever it's taking place. So we really shouldn't be selective in the illustrations and the examples we take. I think that's part and parcel of the response strategy. But really going deeper into your question, I think cultural transformation is absolutely essential. Even though I'm a lawyer, even though I've just spoken for half an hour on legal interpretation, I would subordinate that any day to the cultural transformative project. And that project, unfortunately, is not a quick one. It's not the sort of project that you can implement in a programmatic cycle of 5 years. It's a generational project. It takes education reform, it takes rewriting history, it takes engagement with the actual underlying grievances, whether they're ethnic or economic or class, that actually shape the complexes that plague majority communities and their existential fears as well. I think those underlying problems have to be engaged constructively and not placed in programs that are short term. That is actually a concerted effort over time to transform culture. The reason I say that is that often you would find, if you go back in history, you'll often find that identity formation didn't take place overnight either. These majority communities have come to adopt their majority status based on years, even decades of discourse. There have been ideologues that have really tirelessly, and if I didn't disagree with them so sharply, I would be admiring their work in the sense that the tireless work over years and decades to actually shape this community to believe that a country or a region uh, it belongs to them. Now, you can't undo that very easily without a similar discourse of equal citizenship that has stamina, that's willing to actually go through with the process, meet a lot of obstacles, and quietly make inroads over years and perhaps over a generation. So, just to answer your question, I think the cultural discourse is absolutely essential, and doctrinal interpretation will be left to courts and lawyers and activists. We can make certain changes to a particular extent, but I think uh, it's always limited if the dominant cultural discourse is hostile to what we're talking about.
Thank you, Gehan. It sounds like for Sri Lanka and Myanmar, the future really for a stable, peaceful society is hinged on communities going through this sort of cultural transformation, and to see
Right.
how together, the diversity of our communities and the long-lasting peace is really rooted in assessing some of our own history, as well as figuring out what kind of future do we as societies want to forge ahead. So thank you for addressing that. I'm going to now turn over to the questions that are coming from the audience. The very first question that we've got is sort of, can you talk a little bit about accommodation of harmless, quote unquote, minority practices? Do you think it could lead to an exemption proliferation? Question, Kehan, do you want to take a few and then answer them, or should we stop and address each of them?
If they're similar, maybe take a few, but if this question is a bit of a standalone question, maybe I'll answer that first.
Yeah, let's go because we've
Okay,
got a
okay.
few varieties.
Right. So I have a particular position on reasonable accommodation and that doctrine, which may not be particularly popular. I'm not a fan of the discourse of accommodation, because the discourse of accommodation, for me, legitimizes the majority and minority status of communities. It actually entrenches. Of course, it might be an important stopgap solution, particularly when there's a general rule that requires an exemption, right? Of course, for example, you have a general rule that one has to wear hard hats when engaging in particular occupations, but then a particular religious community that wears a particular headdress might seek an exemption, right? That I think in those contexts we may use the terminology, but as a general terminology, we need to be cautious because again, it could switch the relationship between norm and exception. As far as we're concerned, if we're serious about religious freedom, the norm should be that any community, whether majority or minority, should be able to express their religious beliefs as long as it does not pose a serious threat or harm to another community or another individual. Uh,
Great.
and so I think it's important not to get trapped in the language of accommodation, because that it seems like we're tolerating minority practices as opposed to recognizing their fundamental freedom to engage in that practice in the first place.
Perfect. I've got a second question. It's from an audience member who's from the Ahmadiyya Muslim community in Pakistan. And they asked a question about, this idea of mob justice or vigilantism in
Yeah,
Pakistan, and where
yeah.
the religious right pressurizes courts in deciding cases that favor the majoritarian view. So the question that they have for you is, in your view, how should compatibility between, the good faith interpretation that you outlined in your presentation and the problem of vigilante justice, how do we kind of harmonize these two polarizing viewpoints, so to speak?
That's a great question. Really, this is a challenge that even neutral courts would face. The problem is this: you have one community expressing their religious beliefs in a way that doesn't really harm anyone. Then you have another group, often from the majority community, that takes the position that if the state does not restrict this particular practice, we are going to take the law into our hands and we are going to cause harm, not just to this community, but to everyone. And then you have this dilemma. The state says, oh no, we need to restrict this particular practice, which is actually harmless, because we have another community that is actually threatening to cause disorder. And the court is then sort of coerced, or well, not coerced, but cajoled into actually upholding the restriction. That is, for me, entirely bad faith, because the obligation that the state has is not merely to protect the freedom of religion of minorities and majorities alike. The obligation is also a positive one, to actually prevent public disorder from taking place, to actually provide security to the entire community. So what happens in these cases is that the state offloads that positive obligation onto the individual and says, you're the reason that this public order or public disorder is taking place, so you need to restrict your practice. But that's entirely bad faith and entirely inconsistent with the very idea of freedom, because one should be able to be free to do whatever one likes as long as it does not harm another individual. The fact that some other individual can be unreasonable and harm people because of your free exercise is the state's problem. It's not your problem. So I think what we really have is bad faith. The state hiding behind a majoritarian interest and offloading its obligation in order to justify a restriction that it's actually interested in imposing in the first place, because it actually is hostile to that community in the first place. So I don't really buy the vigilante justice argument, because in practice, the state, which has a monopoly over violence, should be able to protect everyone from disorder, and it often is able to do so when it is interested in doing so.
Third question, Gehan. The Constitution of Pakistan, along with Sri Lanka and Myanmar, has in it sort of a special space reserved for certain religions. So in Pakistan, the state religion is Islam. In Sri Lanka and Myanmar, the special place occupied by Buddhism. So inevitably, even though the Constitution is supposed to have good faith interpretation, inevitably, when the process becomes, adjudicated, naturally these values tend to reflect the majoritarian values. So the question that the audience member have is, can you remove majoritarian tendencies in the court, especially when there's these sort of state identified religions?
So again, a great question, and I think international legal norms are a bit vague and hazy on this, and this is one place to actually critique the norms, because under international human rights law, the adoption of a state religion isn't actually prohibited. It's actually sort of allowed as long as the state does not discriminate against other religions. So it's a little ambiguous, or let's say loose on this particular point, and I completely take the point. The point being that when you have in the text of the Constitution or the treaty or whatever you're dealing with, the privileging of one religion or philosophy or faith over others, you're automatically prompting the state and of course the courts to privilege that particular religion or faith when interpreting the freedom of religion of other communities. And you've seen this in the Sri Lankan context. For example, when a particular religious order wanted to establish an institution that was charitable with the ostensible purpose of advancing the faith through an act of parliament. So the incorporation was supposed to be through an act of parliament. That particular bill got challenged in the Supreme Court, and the Supreme Court struck down the bill because for a number of reasons, but one of the reasons was that it would ultimately displace the foremost place given to Buddhism under the current constitution. So Article 9 articulates that position, and the court struck down the bill on the basis that this would be violative or inconsistent with Article 9. So of course you run into these problems, and I think the doctrinal approach that I propose, particularly in national context where you do have the privileging of particular religions, will run into those problems. But I think having those articles removed has to happen uh, after or alongside the cultural transformation that I'm taking place, that I'm talking about. And I think it's really important to be aware of the backlash that you could encounter when promoting a discourse that is trying to take these privileges out of a constitution without doing the political work, without doing the cultural transformative work. So while I do think that this is an impediment to good faith interpretation, I also think that removing these clauses requires an actual strategy which can, address some of the perceived or imagined existential fears of the community. And I think constitutional reform in that respect has to be cautiously approached. But a great question, and I think food for thought for me as well.
I think one other question, moving away from the religious angle that we've been sort of discussing, is sort of take this question here is talking about the political climate or dynamics. And you talked about a lot of this cultural anxiety, but also how does public interest, quote unquote, what happens when things such as populism that is sweeping not just the region, but globally, how about those forces? How do they shape judicial interpretation? How can we have good faith interpretation when such forces seek to change the discourse? You know, these allegations of terrorism or nationalism, this populist sentiment. What's your comment with regards to that, Gehan?
Okay, let me try and answer that question. I think populism and particularly discourses that are quote unquote right wing or quote unquote security oriented can certainly shape a court's interpretation of or evaluation of limitations, right? So one of the limitation grounds I didn't discuss was national security. Now, incidentally, national security is not one of the limitation grounds that's found in the ICCPR or the European Convention when it comes to freedom of religion or belief, but it certainly is one of the limitation grounds that's available if you're restricting free speech or freedom of expression. But in domestic settings, for example, the Sri Lankan constitution, national security can be one of the grounds on which freedom of religion or belief, particularly the manifestation of religion or belief, could be restricted. So, for example, we in fact did, following the Easter Sunday attacks of 2019, we did have a temporary ban on the wearing of the niqab on the grounds of national security, and this particular restriction was brought in under the Public Security Ordinance under emergency regulations. So you could certainly have a court that is preoccupied with security and influenced by a discourse around security, where there's a bogeyman created in society, and that bogeyman might be typically the Islamist or the Muslim, or in other contexts you could have the leftist or the communist. You could have a variety of these concerns infiltrate thinking of the court, and you could certainly have a national security oriented court, because the court's legitimacy in those societies might actually hinge on how it advances those priorities. So in a society that is completely preoccupied with national security, you might have a court that also positions itself on that spectrum in order to maintain its own legitimacy. So I do think that populist discourse, and particularly discourse that prioritizes security, can shape the way limitations are evaluated.
And one sort of follow-up or comment or reflection on all that you've presented is you shared a lot about the case studies facing Sri Lanka, Pakistan, and Europe, but there's a comment here from one of the audience member who asked if you were planning to look at other countries in the region, namely places like Malaysia, Indonesia, and India, to see how courts in those jurisdictions are grappling. Will that be part of your research in your time with us?
Um, I'm going to have to make sure that I can stay within parameters that's doable, right? I'd love to look at many jurisdictions, but I've sort of arbitrarily picked jurisdictions in which Muslims are the minority and jurisdictions in which the Muslim community might be the majority. I certainly am interested in looking at India, um, because I think what we're seeing in India, even though the communities might be different, there are strong parallels in terms of the discourse, security, nationalism. The economics are also similar in certain ways to what we're seeing in Sri Lanka. And there is some cross-fertilization of ideas. There's certainly, at least in terms of Hindu nationalism, some cross-fertilization between India and Sri Lanka. And we do see some emergence of Hindu nationalist groups, particularly in the north and east in Sri Lanka, which these groups have also articulated a slightly hostile position in terms of the Muslim community, and also in terms of Christian conversion. So I think it's inescapable. I'll have to look at least India. Whether I'm going to look at the entire region is a question in terms of scope and doability. But yeah, great question, and I appreciate that.
I think we have room for just one last question. I'm so sorry to everyone. We couldn't get to all the questions given how rich this discussion is. The final question that I have for you, Gehan, before we kind of close the session is the question about minorities. Do they fare better or worse under secularism? It's pretty broad, but nonetheless, I just was wondering if you could close us off with
That's
that.
yeah, that's another talk, I think. But I do think I do want to leave you with this point. I think the brand of secularism matters. You can have a secularism that is actually hostile to religion, a sort of hostile version of secularism, and we see that in some European countries. And what we have there is a sort of self-defeating secularism, a secularism that actually advances a particular ideology, which itself is like a religion. And that can be a discourse that is oppressive and hegemonic. So it really depends on what brand of secularism we're talking about, because the alternative to that is neutrality and state neutrality, where the state really doesn't take a position on any religion and treats all religions and faiths and non-religions or atheist beliefs in equal terms or on equal basis, is what I think is warranted if we're interested in advancing a good faith interpretation. So I think minorities fare pretty poorly in states which adopt this hostile version of secularism. And I think minorities will do fine in states which are neutral. And what I mean by neutral is that a state that's actually interested in protecting religious freedom and promoting religious freedom of everyone equally. Where we will find in those contexts the idea of equal citizenship. Whereas in other contexts, those who subscribe to the hegemonic discourse of secularism will thrive, and those who believe in a particular faith or adopt a particular faith will not, because they're outside the dominant discourse.
Wow, thank you so much, Gehan, for this incredible hour and a lot of food for thought. And I hope that you all who are tuning in will join us in thanking our incredible guest speaker. Thank you to you all for the excellent questions and for being so engaged. And a special thanks to everyone behind the scenes for bringing us this webinar. Please stay tuned for the next webinar with the Program on Law and Society in the Muslim World. The next session will be on October 7th at 11 a.m. Eastern Standard Time, where we'll be discussing Muslim women's mobilization Foundation for Legal Equality and Justice. Look out for the announcement and Zoom links soon. Be sure to follow the program on Law and Society in the Muslim World on our Facebook, Twitter, and sign up for the mailing list to get the latest updates on our events. And thank you once again for joining us. To all of you, wherever you are, please stay healthy and safe. And thank you very much. Goodbye.